The next case to come before the court is Matheson v. Matheson. Each party will have 15 minutes to present their arguments. The appellant, in this case, Ms. Matheson, will have the opportunity to reserve time for rebuttal up to 5 minutes. If you do plan to reserve time, please let me know, as I'll be keeping track of the time and try to alert you when you go into that time. The arguments are being recorded, so please keep your voices up and stay behind the podium. Introduce yourselves, and you should not use the names of children or minors or victims should that be relevant to your argument. You can refer to those folks by generic terms or initials. And we have, of course, read your briefs and we're ready to proceed when you are. And I would just ask counsel, would you like to reserve time for rebuttal?
Yes, Your Honor, I'd like to reserve the 5 minutes.
Very well, then you may proceed when you are ready.
Great. Thank you, Your Honors. May it please the court, I'm Danielle Kulik, representing Maria Matheson again before you. I know we had oral arguments on a very similar issue with this case the first time around, so I don't want to be too repetitive. But some of the things I wanted to highlight for you going into this one were the fact that with the retroactive spousal support, which was our appeal, that it's even in the testimony that he was paying $15,000 a month to the home, the second mortgage, the utilities, the taxes, all of those things. And when the home sold in August of 2021, they didn't keep status quo. So the temporary orders are to maintain status quo, home was sold, he now nets an extra $15,000 a month. My client is out another $15,000 a month. Home, utilities, rent, everything is on my client to pay, which is not status quo, which is not temporary orders. So we asked for that retroactive increase. The testimony showed that my client was months behind in rent and was facing being evicted at the time of trial. So we do ask that the court reconsider that. I did a lot of math in this brief this time, and I double checked it before you today. So what happened essentially is the court, if you look at the child support order, if you look at all the court rules, had husband at around $619,000. They imputed wife at $19,400. She makes 3% of what he makes, and that's even imputing her. She makes 0% of what he makes. And what happened here is that she was awarded $8,500 a month for 7 years at the end of this case. $8,500 a month is 17% of what he makes. So his testimony showed, he talked about in 1 month he made netted $22,000, another month $43,000, another month $30,000. His varies, but it calculated when he testified on transcripts page 852 to about $150,000 net within 4 months, August through December. So while he has that beautiful net income of $150,000, he's accumulating all these debts. He's taking out debts to pay debts, and he's putting this $150,000, we don't know where. It's not going to the mortgage, not going to the second mortgage, and it's certainly not going to my client. So when we're looking at spousal support, that was the key I wanted to highlight for you today. It's just the disparity. My client is not going to go get a job. She has not worked since before pretty much I was born. So what it shows here is the party's married in 1989. I was born in 88. So if we just look at that, this woman has not worked my entire existence. I'm here arguing before you. I have the training, the education. She doesn't. She can't go out and do what I'm doing. She cannot make anywhere close to the $619,000 he makes. She might not even be able to do the $19,400, let alone when she's age of retirement. She has, obviously they have the retirement accounts. If you look at the docket, he has not signed the QDRO. The QDRO has not been filed, so whether she gets his retirement account, we don't know. But
it's ordered.
It's ordered. But without a valid QDRO, I've seen many cases where they come back and at age of retirement, they have to argue. They say, hey, he didn't sign it, I'm not getting my money. So
as counsel, do
yeah.
you agree that he is working many more hours than he did prior to the divorce?
I don't think prior to, because he owned his own job prior to. He had his self-employment, so I believe the testimony was he was doing a lot more. And then about a month or two into the divorce, he quit his self-employment, sold his self-employment, started working for Mercy, and he's still getting dividends from his self-employment from those outstanding bills. But now he's working, he still works a lot. I'm never going to say he doesn't work a lot. but he's not self-employed anymore. It's not that obscene amount of he has to be on the ground every day for money to come in. He's salaried, he has that income coming in, and then he has that little bit of extra when those bills are collected from his self-employment income that he stopped working. So and again, the record shows he was gonna keep working, he knows he's gonna keep working, and my client wouldn't have me here today if she didn't believe he was gonna keep working. And I know one of the arguments is that spousal support can be modified with a change in circumstance, and I highlighted it for you in the brief, but I wanted to reiterate it today. There's not a change that needs to happen for my client. Everything that existed at the time of divorce is why this should have been extra, why it should have been more. I cannot come back later and say it needs to be modified because he's making $619,000, because this was a 34-year marriage. That already existed. So the change in circumstance, my client won't have that. Now, their client might have that, he might retire, might get injured, things like that, but my client won't. So to modify upward, we won't have that ability. They'll have the ability, potentially, to modify downward with a change. But that's why lifetime modifiable is so important to my client, and the number is so important to my client. So that's number one on that side of things. With regard to their appeal about how the debts were allocated, I wanted to highlight that a lot of this is res judicata. They didn't appeal the first judgment entry, and the first judgment entry already had the BHG, the Best Eggs, and the Lightstream loans, plural, all going to him, and then that $200,000 of extraneous loans and debts that they didn't identify. So when we look at the debts that are husbands, all that's left is the SoFi for $88,000, the Northwest for $155,000, and the Avalon for $270,000. So those are the three things that weren't in the first case. Those are the three things that are now being told are his to eat alone. The other ones are res judicata. And when we look at those, again, the SoFi loans and Northwest and Avalon, they're paying things he was supposed to be paying. They're paying things like tax debts, like utilities. They're paying things like the back, property taxes. And then he's compounding them on top of things, adding insult to injury. So while he's netting $150,000 in 4 months, he's not paying the debts he should have. At the time they filed divorce, they had around $100,000 in debt. His net income for 4 months would have taken care of that, let alone the fact that, again, he's not paying that $15,000 of extra income that he was paying my client for, support from the months of August 2021 to present. He's not paying that, so that's another $15,000 of his income that he has loose. So instead of paying the marital debts the way he should have, status quo, the way they should have been paying them, he took out all these loans, which was a marital waste. He was getting, if you look at it, the debts he was increasing every month on interest was a waste. And again, we have no idea. Some of that money disappeared. He even testified. They added up all the things he said he paid off with a certain loan. And at the end of it, there was thousands, tens of thousands left over. He couldn't account for or testify where it went. So there's hidden money. There's money going places it shouldn't go. He's paying things he shouldn't be paying. And we have his handwritten notes that don't add up. So at the end of the day, I think the court was correct when they said that the debts are his. There are no more marital debts alive anymore. They've all been commingled into this mess of marital waste he created, and he should keep that. The court can consider all the factors when they're looking at these, and my client obviously needs her spousal support. She shouldn't be paying on any of the debts he made. None of that should have been happening. And one of the other arguments I wanted to touch on was they had noted in their brief that they wanted more testimony after this. After the Court of Appeals ruled, well, the rule says if the trial court is not satisfied with the evidence, they can take more evidence. I'm satisfied with the evidence on this. The trial court said they're satisfied with the evidence on this. They had 14 days of trial. I mean, my client would love a second bite at the apple to do a better job at her trial, to produce more evidence, to produce more information. They had 14 days. They don't get a second bite at that apple. They still have the same counsel. They've not changed counsel. There's no ineffective assistance at counsel. 14 days of trial, there was enough information for this court and the trial court to make their determination. For them to say that 14 days wasn't enough for a trial solely on assets and debts for two married people in the state of Ohio would be insane. And again, at the time, they didn't appeal that in the first case, they didn't say we needed more time, the court didn't give us enough time, none of that happened. So again, that kind of issue, it seems to me to be res judicata, should have been brought up before, should have been objected to before, hey, we didn't present the information, we didn't have time, none of that happened in the first case. So I just wanted to highlight those things for you. I believe based on Dr. Matheson's lifestyle, his purchases, his income, and the fact he wants to take less than what he should responsibility for his wife of 34 years, the things she is taking care of, it's in the record that their adult child has a disability. Whether that castle should have been employed, I can't go there today, but when you're considering spousal support, we know she's taking care of that adult child with a disability. We know the expenses, it's in the record, all the different classes and therapies and training that my client paid out of pocket for this adult disabled child. That's all in there and can be considered for spousal support. My client cannot pay the expenses for the adult child on her current spousal support, let alone maintain a home.
You are heading into your rebuttal time.
Perfect, all right, thank you so much, Your Honor.
May it please the court, counsel. Vincent A. Stafford on behalf of Dr. James Matheson. I'm quickly approaching my 5th anniversary on this case. I was lead counsel through 14 days of trial before Judge Janik, multiple issues before this court. While my esteemed opposing counsel was born in 1988, since 1992, I've been doing the most complex contested divorces in the state of Ohio. And I've yet to see a case where a court has awarded lifetime spousal support. Much like the dodo bird, that is long extinct in the axiom of Ohio law, where someone is getting lifetime spousal support.
Right, but here, don't we have 7 years in a 34-year marriage when the guidance is at least a third of the length of the marriage?
Well, I don't know, depending what county you're in on guidance, Your Honor. If you look at guidance of counties, these parties should have never been in Lorain County. They didn't live in Lorain County. Their assets weren't in Lorain County. It was a form shopped filing in an attempt to get more spousal support because they're from Erie County. But because Dr. Matheson took
Did you
call.
challenge that?
We did, Your Honor. It's because Dr. Matheson took call at a Lorain County hospital, that's why we're in Lorain County. But let's look.
Well, isn't that the problem? Shouldn't there be more certainty of how we calculate spousal support? And that's what the law provides for us, a third of the length of the marriage, equal division of.
That's a rule of thumb that's great for Cuyahoga County. Other counties that surround Cuyahoga County is 5-1. If I were trying a case in Geauga County or Medina County, it might be 6-1. So again, we have established law, so we have a lengthy marriage. Wife is a dentist who has not practiced. Dr. Matheson is 67 years old. Now let's look at his day that's in the court record. He starts work as an employee. He is a high-risk pregnancy management surgeon. He starts work at 7 a.m. He works all day at the hospital or in office until 6 p.m. The record shows that at least 7 to 10 times a month, he has to stay overnight at the hospital from 7 p.m. until 7 a.m. Now, let's think about that. You do surgeries all day. You get off work at 6 o'clock, and you start your overnight at 7 p.m. to the following morning, where you are responsible for triaging emergency pregnancy, emergency labor, C-section, emergency delivery for multiple women throughout the county and surrounding counties. That is my client's life.
Counsel, I'm just not sure I understand. I guess that's all in the record, and I think she's not suggesting that he's not working very hard and long hours and so forth. But isn't that his choice?
No, well, it's a great question. So the evidence Judge Carr, is that traditionally he operated his own regular practice. His traditional income was about $250,000 to $275,000 a year. The evidence showed that their finances were a disaster. The records replete. They didn't pay quarterly taxes, so they always had a $30,000 to $50,000 tax bill every year. And I think the record has demonstrated that they're still pending the 2021 joint tax return of $40,000 that was never addressed by the trial court. That's still owing to the Internal Revenue Service. So they got in this habit of overspending. They had 9 children that all went to college. They had a $1 million home on Lake Erie. Despite having a $1 million home, they only had a couple $100,000 of equity in the house. They had no real savings.
I need to stop you here, but we're really focusing on spousal support here.
So,
And so there's guidance, there's law we have on spousal support and how it's calculated, and there's an argument about spousal support not being appropriate in this case. What's your counter argument to that?
well, if I can finish my response. So his traditional income was $250,000, $270,000. When the divorce is filed, he gets hit with an order of $20,000 a month. That is gross. He has to make $400,000 to pay a $20,000 a month expense bill. So the expenses went through the roof. So what he had to do was take not his job, not his contract. He had to take additional call hours, which are completely voluntary in the divorce case. So because he had a $20,000 a month obligation that he had to meet, he had to work additional calls. So his income went from $250,000, $275,000 to $500,000 plus. And that's only as a result of call hours, those 10 additional nights a month that he was working. This guy can't work and sustain a $600,000 a year income because it requires him to work 2 jobs. So the court was presented with that fact. Mrs. Matheson didn't present her expenditures. None. 0. No budget was submitted to the court. And counsel raised the issue of retroactivity. When the marital residence sold, if the court looks at the record in the docket, she was hiding with the minor child that she refused to turn over possession of. She wouldn't disclose where the child lived. She didn't give that information. We had emergency custody proceedings. We had a contempt finding. She got hit with sanctions for attorney's fees. That's the period that we're talking about.
So what does that have to do with retroactive spousal support?
Well, Your Honor, she claimed, her argument was just that she had no money to support herself. But yet, you'll see in the record that she played a game with her lawyer, Mr. Bunchy, of hiring and firing before a trial. She was able to pay him in, I believe it was August or September, $22,000. So while she's claiming to the court that she has no money, she was able to pay her lawyer $20,000 in a cashier's check.
But isn't spousal support not about just making it? It's about living at for a period of time at your customary living experience. I don't have the right word here, but it's not about, okay, we're going to make sure everyone's provided for with the spousal support, and that's it. It's about he makes X amount of money, she makes X amount of money, and it's about living at the level that she lived at when she was married for that period of time.
Well, one is the lifestyle. That's one of the criteria that the court can obviously look at. 2 is the income, and the historical income of the parties was $250,000. While they lived in a $1 million home, they had no real money.
So every time we have a rich person who is being divorced, a person with a high income, we can't, are we going to make spousal support way lower because it's good enough? I mean,
no,
shouldn't there be math involved here and all those types of things?
Unfortunately, there is not in a mathematical formula that any court has utilized. There's not a 1/3, there's not a 1/2. It's a sliding based on the fact of the criteria. So to understand the court, so the court understands, for Dr. Matheson to pay what he's obligated to pay right now, he has to make $200,000 gross. $200,000.
Is that difficult for a surgeon?
His historical yearly earnings was only $250,000 gross, historical, through all their tax returns, through 30 years of their marriage. He only made $250,000 a year. But once the court put on the support order that it did, where he had to survive on 2 households, he had to get a second job where he worked 20 out of 24 hours, 2 or 3 days a week, Your Honor. So imagine the court having trial all day from 8 to 6, then having to do night court from 8 p.m. to 6 in the morning, 3 or 4 days a week. That's the schedule he currently is under with the obligation during the divorce. That is,
But he's not under that now, because it's $8,500 a month.
he's not under that now, Your Honor, but believe it or not, in order to pay the $8,500 a month, because his contract is only $300,000. So his contract,
That's gross.
that's gross. So he nets out about $150 off his base contract. And he has to pay her, after tax, $102,000, which leaves him about $48,000. That seems like a fantastic deal for a 67-year-old surgeon. But he has to work extra to achieve that order, and he does. This is a guy that works like a Clydesdale horse, but you can't expect him to work what was done during the 2-year period of the divorce. It's not sustainable.
Well, a contrary argument to that would be, okay, then this is what he's currently earning. If he can't maintain that, that's why the court kept jurisdiction, so that the court could change the spousal support.
That's exactly what the court says.
So
and
what's
that's
wrong
why
with that? Isn't that what you do? Isn't that what a court does?
That's exactly what you do. So the testimony is that he's on a yearly contract with the hospital system. Whether that gets renewed is a year-by-year basis. He doesn't expect to work as a surgeon much past 70. It's a tough lifestyle. He's on his feet, he's delivering babies. It's not, there's a certain life expectancy of a career of a surgeon. And at that point, the court recognized that that might be an appropriate station for a modification or termination of spousal support, and that's what the court did. He's already paid 5 years of support, 5 years. So again, even if the court looked at a 3-to-1 multiple, he's at 12. Under your theory, Judge Lanziger, you want to use your 3-to-1 theory, you want to use your 5-to-1 theory, he's right in that zone, and he is paying a lot of spousal support, let's be clear. While we hear numbers of $600,000 of income, $300,000 of income, if you actually look, there's no savings that was divided in this case, because there wasn't any. The equity of this $1.5 million home was $260,000. The retirement that was funded through debt service was $1 million and divided. So for 32 years, for a surgeon, they had about $1.2 million. That's not a significant amount of money. When you have 9 kids, you educate them, and you send them off on their journey, parents oftentimes don't have a lot left. So we would ask the court to look at the totality of the order. He paid $200,000. He paid over $200,000 a year in temporary support. They sold the marital residence. I think it closed in late July, early August of 21. Trial was in November of the end of 21.
And when did it end?
I'm sorry.
When did the trial end?
I think it ended in mid-March of 22. After some breaks, there were some issues of her counsel and herself. So during that period of time, bills and expenses were currently paid. Addressing the debt, the trial court found there was $200,000 in marital debt in its judgment entry. After remand, the court found that there was no marital debt. That's a complete 180 reversal. The facts are they lived on high interest credit cards, 25% a year. There was requests filed in the court to refinance the house at 2 or 3% so they could consolidate all of these credit card debts. That never received any traction. So he's paying $200,000 in debt at 25% interest during the pendency of the divorce. So what would occur is that he would use a zero introductory interest credit card to consolidate the 25% credit card. Then he would get a low interest loan and consolidate that once it came
It
due.
seems though like the court was saying there's no marital debt because it seems like the court is saying that there was basically financial misconduct, that he didn't obey the court orders, that he was not supposed to be refinancing anything. Isn't that what the court said? The court said he didn't, the court said he didn't obey the court orders by refinancing and so forth. He wasn't supposed to take on additional debt or anything during the pendency of the divorce.
I would disagree with you, Your Honor. I don't think there was any issue of marital misconduct or financial misconduct.
Well, he still, whether you're gonna call that or not, the point is he was taking on additional debt during the pendency of the divorce.
Taking on additional, consolidating debt is not unusual during divorce litigation. You have super high interest loans. So for example,
I believe the language was robbing Peter to pay Paul.
that's the history of the party's marriage. So for example, he had to fund his pension, $30,000 in the record. They borrowed that money off of, I think, a cash advance to pay it. And she got half of the pension money, but she didn't get the debt used to fund it. That's an example. So
Counsel, I
Sure.
appreciate that clarification, and, but you are running out of time, so if you would like to summarize.
Sure. Thank you, Your Honor. Your Honor, appreciate the time for Dr. Matheson. He had $200,000 in marital debt. It was paid by new debt. It's the same money that was always owed. It's just a different financial institution. They created this. There was no real assets to divide in this case, but there was debt.
We have to wrap up.
Thank you, Your
Thank
Honor.
you so
Appreciate
much.
your time and attention.
Thank you, counsel. You will have 4 minutes and 48 seconds for rebuttal.
Thank you, Your Honors. I apologize for having to bring the laptop up here, but this was the first time I heard that he thought they objected to venue. So to look at his answer and counterclaim, it says defendant James Matheson sets forth that he has been a resident of Lorain County for more than 90 days and the state of Ohio for more than 6 months immediately preceding the filing of this counterclaim. The plaintiff, Maria Matheson, has assets in Lorain County and the venue is proper pursuant to Ohio Civil Rule N3C135 and 9. And that is the counterclaim filed by Joseph Stafford in this matter. There were no motions, no 12B motions filed before that pleading, and obviously they never contested venue. To say that Lorain County is the better venue for forum shopping, one, didn't forum shop, they liked the venue, they consented to the venue, and two, in my experience, which I know, as he pointed out, is less than his, I haven't seen that to be true.
Counsel?
Yes.
Let me direct you to some other issues if you don't care.
Absolutely.
Do you agree that the affilee husband was earning $250,000 a year prior to the divorce?
No, so I didn't see that in the record, the $250,000 a year. They definitely had a lot more money than that. I was double checking the transcripts too while we're looking at it, and if you look, he testified about his W-2s. You know, he talked about, and I was gonna touch on that too, the second job that I'm hearing about for the first time today, I don't see that in the record either, there was ever a second job. But his Mercy job, he has the W-2s. Then he had those dividends I was telling you about from, you know, the collections that happened on his other job.
Right, but I'm
Yeah.
specifically speaking of before he had his Mercy job, whenever he had his own private practice, what was his income?
Off the top of my head, I'm not sure what his income was, but I believe it was significantly higher than at Mercy. Just because I know that was an argument that was made, is that he, became less employed.
Let's pretend,
Okay.
let's just hypothesize that his income was lower.
Mhm.
How does that affect your argument?
So if his income was lower when he was self-employed, and then he goes and takes the Mercy job, fantastic, we're so happy he took that Mercy job, but his income is still high. His income, while he was testifying, those months I was telling you about, August, September, October, November, December, he had the Mercy job. and he netted that $150,000. So my argument, I wasn't trying to impute him at the old wage or talk about his historical earnings. I'm just saying this man himself during this trial while working at Mercy had $150,000 net in 4 months.
But doesn't that go to the, like some of the questions Judge Lansing was asking that I think are very appropriate in regard to the spousal support and keeping equity as to both the households? If he wasn't earning $600,000 a year during the marriage for 32 years, how can you say the wife should be entitled to a $600,000 lifestyle?
Well, we look at the time of the divorce, the final hearing of divorce, unless there's a de facto date. Here we don't have de facto. And so when we're looking at it here, we're looking at the numbers as of the date of the hearing. And I believe it is appropriate, if you do the extrapolation, 4 months at $150,000, that is net $450,000, which we all know with taxes and everything, that means he made over $600,000 gross. And so when we're looking, since it's not a de facto, we're looking at that end date. Another thing that I wanted to point out that he mentioned was my client was able to pay her attorney's fees. No, she wasn't. She used her inheritance, that's in the record, and a friend loaned her money, that's in the record. So that's already there. I did touch on the second employment, that's not there.
I'm just interested in one thing real quick.
Absolutely.
9 children, when this brief was filed, you say 2 were minors?
One was a minor and one was an adult disabled child.
Okay.
Yes, the one they adopted from Ukraine, that's in the record. As well, again, they didn't go into castle, I'm not trying to, but it's something we can certainly consider because there's never been any testimony that anyone other than my client took care of the adult
Who
disabled.
has custody of the children now? Legal custody?
Under the court order gives the minor child to husband, and I'm probably not allowed to bring up what's actually happening, so.
That doesn't matter.
Okay, yeah, I don't want to go
I'm just
there.
asking.
Legal custody went to him,
And the disabled child is?
with her, there's no court order.
There's no court order.
Yeah, because they never did the castle analysis, whether right or wrong, but the testimony at the time showed that that child was with my client. And as far as the his financial misconduct that Mr. Stafford said didn't exist, the violation of the mutual restraint in itself was financial misconduct. Him taking the fifth, as I put in my first brief when we first argued here, I had plenty of financial misconduct listed there, so I don't want to go back into it. The fact that he said he had to fund his pension, I didn't see a court order that ordered him to.
You two are running out of time, so please summarize.
Thank you, Your Honors. Just in summary, the 180 reversal he was talking about has to happen because obviously this court ruled that it was an improper judgment entry. So I feel the trial court did the right thing in this case as far as the debt, and I hope that one day they'll do the right thing for spousal. Thank you.
We thank you both for your presentations, very helpful. The court will take the matter under advisement and issue a decision in due course. The court, of course, will mail a copy of the decision to you on the day that it is released, and the opinions will also be posted on the Ohio Supreme Court website. Thank you both again.
Thank you.